We'll go with Mr. Robert Silverstein with 10 minutes.
Dougie Fresh.
Good morning.
Good morning. Thank you. First of all, since Mr. Resnick is not here, if I may request that his time be added to mine, and I will do my best to speak on more issues.
Unfortunately, we cannot do that. We can give you the 10 minutes, but if he's not here to yield it to you, then we'll go ahead and give you your 10 minutes, though, as we did with the supporters and the appellants. Thank you.
There are two appellants here, and I think in terms of due process and given the gravity of the situation and the decisions that are before you today.
This is part of your time, so if you want to.
That are before you today, I would respectfully submit that you should give more time to this, not less, which really raises the issue, what is your rush? My name is Robert Silverstein, and I'm the attorney representing a coalition of more than 40 community groups that have coalesced around this project, against this project, because of its outrageousness. Let the record reflect, first of all, that I filed some objections this morning with your city clerk's office, 3 separate letters. One is to Council President Wesson, one is to your Department of Building and Safety, and another one is to Council President Wesson with some exhibits. We have tried our best to respond to a last-minute document submission by the developer of 311 pages, and I would respectfully submit that that action by the developer and this City Council's endorsement of that action is a violation of our due process rights. There is simply no way in the limited amount of time that we've had that an appellant, a land use appellant, which is what we are, can have assimilated that 300 pages of material. What we did notice in our initial review is that they have attempted to sneak in new studies, new data, all of which are similarly false to what they did before. However, the entire purpose of CEQA is that it is a public disclosure document, and CEQA requires that both you as the decision makers and we as the public have a full and fair opportunity to review and analyze the information that's presented. That has been rendered impossible by that procedure from the developer. And I would respectfully remind you that last August I won a trial in the Los Angeles County Superior Court against you, the City Council, based upon the Hollywood and Gower project, where the city staff and planning department and you allowed the last-minute introduction of material backfilled into the record written by the developer and denied our client, the La Mirada Avenue Neighborhood Association of Hollywood's due process rights. And Judge Jones downtown found that the city violated our constitutional rights. A very similar abuse is happening here today, and that is a further ground for you to take a step back and not to vote to approve this project. And I would specifically encourage Councilmember O'Farrell to give this his attention, because this is not only a horrific project, but it's a horrific abuse of the process. What the public wants to see is integrity in the process, and that is sorely lacking, and there are so many examples of that. In the last couple of days, some startling information has come out which further blows the lid off of this project, exposing the danger and fraud surrounding it. First of all, the California State Board of Professional Engineers and Geologists has opened an official investigation into the Millennium developers' geologists. That is in response to our formal complaint that the developers' engineers distorted their technical reports to hide the existence of the Hollywood earthquake fault running directly through this property. We've been claiming, and now the state is investigating, that the Millennium geological engineers have misrepresented the facts about the life, health, safety risks of building skyscrapers on the property at issue in this matter. The State Board would not have opened this investigation if they did not believe that there was probable cause to our complaint. They are not required to simply open an investigation. Second, the other dramatic development is that last Saturday, 4 days ago, the California State Geologist Parrish, in a letter written to you, the City Council, and Council President Herb Wesson, wrote with specific reference to the EIR in this matter and with specific reference to the Millennium Project that the California Geological Survey has commenced a detailed study of the Hollywood Fault and its related splays. Dr. Parrish noted that the state's investigation could affect the city's, quote, reviewing of plans for the prospective Millennium Hollywood project, which may fall within an earthquake fault zone. All independent data shows that it does fall within an earthquake fault zone. More than that, that faults run through that property. Where do we know that from? From the 2010 California Geologic Survey's active fault trace map, which was ignored by the developer's consultants. From Professor Dolan from USC, who has no dog in this hunt, who is the world expert on the Hollywood Fault. His studies, from prior studies, all peer-reviewed independent studies that were suppressed and ignored by the developer's consultants. That is fraud, and your approval or anticipated approval is endorsement and complicity in that fraud. You need to step back and do what a responsible city council would do, which is, Councilman O'Farrell, at a minimum, wait until the State Geologic Survey's investigation is complete. They have said that that's only going to take 6 months. We're not talking about years or decades. 6 months. Instead, what will happen today is you will put the lives of as many as 3,000 persons, including our respected union members, who would work, live, and shop in that giant project. They would be at risk if you approve this project today. These are devastating new developments. These are red flags that should warn the LA City Council that it would be irresponsible and possibly criminally negligent for it to approve the Millennium Project as it is now planned. All of this new information must be disclosed to the public in a new draft EIR before the City Council votes on it. You cannot take the approach that you seem to be taking with yet a new amended ordinance 5 minutes before this starts, where you're adding different things or claiming different things, all window dressing, saying that there will be further seismic studies done to your satisfaction. That subverts the entire purpose of CEQA, which is the information needs to be in front of you before you make your decision, not afterwards. If the Department of Fish and Game said to you, we are investigating and we have commenced a study of an endangered species on the Millennium Hollywood project site, and I would respectfully submit that integrity is an endangered species on that site, but if they said that to you, would you still go ahead and ignore it? Ignore the state's study? Ignore their jurisdiction? That is what you are doing. Moreover, for 2.5 years you have ignored Caltrans's jurisdiction. For 2.5 years you have ignored the statements and the directions from Caltrans, which is a responsible agency, which has said that your EIR uses bogus figures and falsifies data and suppresses information about massive impacts to the 101 freeway, to the circulation system, to safety, to emergency response times, to queuing. None of those issues have been addressed to date, despite Caltrans's repeated and consistent objections to this EIR. It is unheard of that you have 40 community groups plus 6 neighborhood councils that have coalesced against this. It is further unheard of that you have at least 3 state agencies which are now involved saying to you, City Council and Councilman O'Farrell, please stop. Do the responsible thing. At a minimum, wait for the studies to be complete. Do not ignore what is so crystal clear. Do not rubber stamp this. Do not conduct business as usual. We want to see better. You are our leaders. We expect responsible leadership. We still have a shred of faith in the process. Please, please don't disappoint us. I know that's a big request, but, you know, hope springs eternal. So we would respectfully request that you defer any decision until after the state's investigation is complete. I would also respectfully suggest that your Building and Safety Department, including Supervisor Chan and your city geologist, Mr. Prevost, have been woefully negligent in their advice to you. They should have advised you to stop and to not accept the geological studies that are underlying and undermining the EIR and your decisions here. I believe when you approve this, if you do, and when everything falls apart, which it will, that there will be a seismic shift within the Building and Safety Department, and that's desperately needed, because instead of being gatekeepers, they have rubber-stamped, clearly fraudulent and erroneous studies. And I want to briefly mention, in the few minutes that we had to try to assimilate the new material they've dumped into the record, they claim, the developer, that ZEMIS, the City Zoning and Information System, is an adequate basis, a legitimate basis for determining the distance to the earthquake fault. That's a ridiculous statement. There is no basis for that. It's not a geological survey. They also falsely claim that our experts relied on ZEMIS. That is also a misstatement. Our expert referred to ZEMIS when critiquing their experts' reliance on it. Everything that they are saying is twisted. Everything that they are saying is misleading. Everything that they are saying is dangerous. And you have an obligation to stop this project
Thank
now.
you. Your time is up, Mr. Silverstein.